Kim Mutcherson, co-dean of Rutgers Law School in Camden, and this is The Power of Attorney. So we're continuing our ongoing series of interviews with folks from our faculty, and I feel very lucky today that I'm able to snag Professor Stacy Hawkins from the Camden campus, and I'm looking forward to our conversation. Thanks for taking the time to talk to me today, Stacy.
Thanks for having me. I'm very excited to be here.
Awesome. So obviously the world is full of opportunities and you could become a million different things in life. And yet you chose to become a lawyer and then ultimately to become a law professor. So were you one of those people who was running around on the playground at 10 years old saying you wanted to be a lawyer? Or was it something that came to you later in life?
It was 6, actually. I know, right? From like the first or second grade, I knew I wanted to be a lawyer. And I was very much encouraged by everyone because I've been argumentative all of my life. And so people thought, yes. And I got a lot of positive feedback. And so I never veered from that ambition. I've wanted to be a lawyer since I was about 6.
And what did you imagine? I mean, obviously, when you were 6, your vision of what being a lawyer was very narrow. But as you got older and continued to focus on becoming a lawyer, what did you imagine your career was going to look like? What did you want to do with that law degree?
Well, I think that I had really disparate visions, right? So when I was growing up, I'm a child of the 80s. I had like the LA Law, Blair Underwood version. And then, of course, there's Thurgood Marshall, who I wrote about for my law school admissions essay. My mother bought me a book on Constance Baker Motley. Was one of the Black women who was involved in the Brown v. Board of Education case on behalf of the NAACP. Oh, and there was also Felicia Rashad, right? And Claire Huxtable character.
Right.
But I had very limited role models of lawyers in my personal life. And so there were all of these kind of various ways of being a lawyer that I saw, and I wasn't really sure which of them I would emulate, although I was most drawn and have always been most drawn to civil rights and particularly advocacy on behalf of racial minorities and Black people in particular. So I really did imagine that my career would resemble something like a Constance Baker Motley, Thurgood Marshall, with the exception of ending at the Supreme Court.
That's funny. That's very much sort of my vision too, or was my vision, that I was going to be sort of like a female Thurgood Marshall. And yet here we both sit as legal academics. So that's definitely not where we ended up. I know that you went to Georgetown for law school and then practiced law for a while. So can you talk a little bit about what your legal career was like when you were actually out there being a lawyer every day?
Right. So my decision to be a lawyer was much more deliberate than the path that my career actually took. And certainly my decision to become an academic, that was much more haphazard. Mm-hmm. But so I really did aspire to be a civil rights lawyer. And I actually thought I would pursue that right after law school. But it just so happened that personal circumstances took me to New York, which, as most people know, is a very expensive place to live. I had lots of law school loans, and I had, I think, maybe 3 or 4 job offers, and several of them were for public interest organizations, including for legal aid, and one was for a law firm, just kind of a random contact from a Georgetown alum that I'd made because, again, I happened to be in New York, and so I was doing a lot of networking. And so I got the offers, and all 3 of the public interest offers were in the $30,000 range. And at the time, the private law firm offer was, I believe, $80,000, which I know is shocking to your listeners, but that was the top of the legal pay scale at the time. That was New York law firm pay rates. And obviously, I consider those 2 options. And being the very pragmatic person that I am, I thought, I can figure out a way to turn this into some good civil rights lawyering, but I have to collect this paycheck first.
Right.
So I went to the private law firm, and that's how my career started in, major defense firms. But I did managed to find my way back to civil rights law, first through employment defense work. And I know people don't think that employment defense is civil rights work, but obviously I was at least working with civil rights statutes. I was becoming familiar with, I was practicing in an area that was heavily steeped in civil rights law, even if I was, as people would often tell me, on the wrong side
Right.
of the battle. But then I found diversity work. And that's when my career really, I think, took the turn that led me to academia.
Oh, excellent. I would definitely want to talk about diversity work and sort of what you mean by that term and how it became a part of your career. But I also think it's really interesting what you said about, doing employment work, but doing employment work on the defense side. So for, employers who were accused of discrimination or other sorts of not so nice things. And one of the things that I think is really interesting just about the law in general is it's often the case that people will start practicing on a particular side of an issue. They learn lots of lessons from that, and then they change sides, right? It's the person who starts as a prosecutor and then opens up their own criminal defense practice, right? I mean, there's something to be said for the kind of training that you can get by doing the work on either side of it. So I don't think you were on the wrong side there.
Thank you very much.
You're welcome. So let's talk about diversity work. So when you say diversity work, what does that mean? How do people understand that term?
Well, I think most people have some familiarity. I mean, diversity's been a popular buzzword for probably about 10 to 15 years, although my exposure to it started about 20 years ago now. But it really is this evolution of the civil rights agenda that was started with civil rights statutes and then the equal employment opportunity and affirmative action work of the kind of 60s through 80s. And as we experienced a little bit of a backlash to affirmative action, particularly during the Reagan years, employment managers and HR personnel started to try to make these programs and these efforts more palatable in this kind of hostile environment. And so affirmative action wasn't a very popular idea, but they started to talk about the business benefits of having a diverse workforce. And so they really started to push equal opportunity and efforts that still felt and looked very much like affirmative action, but were just justified by business needs rather than being justified either by remedying past discrimination against women and minorities, or by legal compliance, right? Because civil rights statutes and certainly affirmative action regulations of the 60s and 70s, they required companies to take this affirmative action. And after that really stopped, companies, or at least HR personnel, wanted to continue these efforts, but they had to kind of reimagine them. They had to justify them in different and new terms. And that's how diversity came to be.
Got it. So one of the things that I think is, instructive in this realm is paying attention to how the law and in particular Supreme Court cases, so I'm thinking of Bakke and cases like that, how they had an impact on this turn from we're remedying past discrimination, looking at this country's history and the many, many ways in which people of color, especially Black people, have been kept out of power and kept out of opportunity. And we want to sort of fix that versus the shift that you talk about to this shift of, talking about diversity and sort of equal opportunity and, the importance of people being able to mingle. So can you talk about that, how the Supreme Court and some of these affirmative action cases really required people to start thinking very differently about how to have a diverse workplace?
Absolutely. So Bakke was, of course, a part of that backlash that I talked about earlier, right? So the backlash against affirmative action that we started experiencing really, I guess, as early as the late 70s, right? Because Bakke is 1978.
Can you tell folks who are listening what Bakke is, what that case was about?
Sure, absolutely. So Alan Bakke was a white male who had applied to the University of California at Davis Medical School. And at the time, UC Davis's medical school had an affirmative action program where out of the 100 seats in the entering class, they reserved 16 of those for underrepresented minority students. I mean, there was a separate admissions program for the 16 slots in that program. And Alan Bakke applied, and because he was a white male, he was only eligible to compete for the 84 seats that were not reserved for minority applicants, and he was denied admission in that pool. And he sued, saying that his inability to compete for those additional 16 seats, and in particular, the admission of people within that pool of 16 who had lower academic credentials than he did, violated his right to equal protection under the law. And so really it was like the first time we really started to talk about this idea of reverse discrimination, right? So
Hmm.
traditionally, we thought of civil rights and anti-discrimination law as protecting women and minorities against discrimination by the majority. But Alan Bakke showed us that the Equal Protection Clause in anti-discrimination law is actually race neutral, and that white people and men can use it just as well as women and minorities. And they did, and they began to use it with some force and success in the Supreme Court. And so Alan Bakke actually won his case, although it was a very fractured decision. And one of the things that the writing justice, Justice Powell, wrote was that while the University of California at Davis could not use this minority set-aside program to remedy past societal discrimination, because there was no indication that the UC system itself had engaged in past discrimination against minority applicants, and they were not allowed to use their admissions program to broadly remedy societal discrimination. And the majority of the justices agree that that was impermissible, but at least one justice, and certainly there were four other liberal justices who thought that, race should be broadly used for these remedial purposes. But Justice Powell said maybe what we could see as permissible under the Equal Protection Clause is trying to achieve student body diversity. And so certainly that's part of what HR and employment managers seized on in developing this idea about diversity. But it's interesting. I wrote a paper on this early in my career. It really wasn't academia that generated a real practice and a real discipline around diversity management, and this idea that we should look at the positive benefits of having racial and ethnic diversity rather than thinking about it in terms of remedying some past discrimination, right? So instead of remedial aims, we should think about hiring and or admitting women and minorities in large numbers because of the benefits that they bring. And so that's really what Bakke did. Number one, it really set the stage for this backlash against affirmative action and the closure of the remedial justification, or at least the narrowing of the remedial justification for affirmative action. But it opened up at the same time this new avenue for thinking about it.
Right. And Bakke, as you said, was in the late 70s. And yet we are still having the same fight about affirmative action and about educational institutions in particular, trying to figure out how to have a student body that is not completely homogenous. Right. So we had Grutter, and, we have other cases that are continuing to come up. Hopwood in Texas. So I guess the broader question I would ask you is whether you think that we have turned a corner on these affirmative action conversations. Are we still basically stuck in the same place? What do you see as the future of conversations about how to, one, about affirmative action in general, which I think has really become sort of a negative term in lots of ways. But also, if that's not the way that we're going to think about how we change our workplaces and our universities and our colleges, then what should we be talking about instead?
Yeah, so there's a lot to unpack in that question. So, first of all, I think that it is, right, a little bit discouraging that we are still having this conversation. We are still litigating what I call race conscious admissions, right? So the Bakke case was about a specific set aside program, which the court categorically said are unconstitutional, and those are no longer in use, either in education or in employment. But race consciousness, right? Whether or not either institutions, educational institutions, or employers can consider race at all when they make decisions about whom to admit or whom to hire. And that's a kind of more complicated question. And I would say that we turned one corner. You mentioned Grutter, right, in 2003, where, again, I mentioned Justice Powell in the 1970 Bakke case said, well, maybe we can't do this in order to remedy past societal discrimination, but maybe institutions can do this if what they're looking to do is achieve student body diversity. And why? Because there are positive benefits that accrue to institutions when they're diverse. Some of those include that students have a better classroom experience, right? They get to learn from people of different perspectives. Not only that, but it breaks down racial stereotypes. And if we want to live in a diverse and pluralistic world, we have to learn how to get along. And then finally, we had become by that time a very global economy. And so, in order for students to be prepared to go out into the world, I mean, after all, that is the object of higher education, to prepare people to go out into the world, they needed to have the skills, right, to navigate these diverse workplaces. And so, all of these beneficial reasons, the court said, would justify a university's consideration of race and admissions. And so that was in 2003 in the Grutter case. The court finally agreed, a majority of the court finally agreed with Justice Powell from Bakke and said, yes, diversity is a interest that will justify the use of race under the Equal Protection Clause. And that, I think, was an important turning point, right? People celebrated, colleges and universities. In fact, you talk about Texas. So after Hopwood, the case that you mentioned, which was a 1996 case, the University of Texas had not been able to use race in admissions because under that decision, the Fifth Circuit had said they could not. Once Grutter comes out in 2003, the University of Texas returns to the use of race in admissions and dramatically increases, well, significantly, I won't say dramatically, significantly increases race in admissions. And so they are sued again in case Fisher versus Texas. And that goes up to the Supreme Court twice, in fact, once in 2013 and again in 2016. And ultimately, what the court says is that there has to be this very, very narrow consideration of race. And colleges and universities can't expect to use these race-conscious admissions plans indefinitely, even when they're designed to achieve student body diversity. There has to be some limit because, quite frankly, the court has, since this backlash going all the way back to 1978, been extraordinarily suspicious of the ability to use race in ways that do not offend our Equal Protection Clause. And so the court said that the University of Texas passed the test of narrow tailoring in that 2016 Fisher case. But that decision was authored by Justice Kennedy. One of the things, I don't know if you've talked about this before on the podcast, but the Supreme Court usually is ideologically divided. And in the middle of the court sits what we call the swing justice. And Justice O'Connor, interestingly enough, right, Powell had been a swing justice back in 1978 when he authored the Bakke decision. Justice O'Connor had been the swing justice in 2003 when she authored the Grutter decision. And after Justice O'Connor retired, Justice Kennedy became the swing justice in 2016 when he authored the Fisher decision. And so all of these decisions continuing to provide some avenue for continued consideration of race, even if it wasn't this remedial treatment of race that was traditionally associated with affirmative action, there was still an acknowledgement that race was relevant even in our contemporary society. But it seems that we may be taking a new turn, and it may not be a turn for the better, because Justice Kennedy has now retired from the court. We all know that he's been replaced by Justice Kavanaugh, someone predicted to be much more conservative than Justice Kennedy, has already proven himself to be more conservative than Justice Kennedy. And so there is a case currently pending against Harvard University, another one against the University of North Carolina. So this issue is wending its way back up to the Supreme Court yet again. And it's not entirely clear that the court is going to be as receptive. The new moderate, at least by lots of people's predictions, curiously enough, is the Chief Justice. And he's not very moderate at all. I mean,
Yeah.
he's not one that you can consider a reliable swing vote. He certainly does side with the liberal wing of the court when what we call the court's integrity or charges of their lack of political independence can be levied about a particular case. So for instance, the recent abortion case, Chief Justice Roberts was likely very concerned about charges of the court being politicized by reversing the court's longstanding precedent on Roe v. Wade. And so he voted with the liberal wing of the court. But he's not a very reliable swing vote. So I'm not sure, and he certainly has not voted in favor of any race-conscious program since he's been on the court. It's not entirely encouraging that not if, but when these cases go back up to the Supreme Court for consideration, that will have someone like a Powell or an O'Connor or a Kennedy willing to continue to allow the use of race in admissions or possibly even in the future in employment, because the two
Right.
are very parallel.
Right. One of the things that I think is really challenging in this arena, I mean, obviously in this country, talking about race is always very challenging. And one of the things that we saw in the affirmative action discussion over the years was this shift to saying, if we want to stop racism, we have to be colorblind. If we want to move beyond race, we have to stop talking about race, which is obviously, I think, a really dangerous position to take and not a particularly useful position take, but certainly that's a piece of the puzzle here. But I also think that this shift to the diversity rationale and no longer talking about remedying past discrimination is a sort of attempt to whitewash, if you will, the history of this country and the impact that the treatment, particularly of Black people in this country, but lots of people of color, Indigenous people, people of Asian descent, that this country started off pretty bad in 1619, and there continually have been these ways in which law, in particular, has been used to keep people from being able to move out of a particular positioning. So it seems to me that we've lost something really significant in not being able to have those conversations in the context of the law. And we're in this really interesting moment, obviously. George Floyd's murder at the hands of police officers, this sort of resurgence of the Black Lives Matter movement. Of course, it never went away, but people talking about it much more and much more openly. And I wonder if there's any sense on your part that we're at a tipping point, maybe, where people in the majority are much more willing to start having these very difficult conversations about how present history is, right? It's not just something that happened all these centuries ago, but it continues to have this significant impact on how our world is currently organized. What's your thought about that?
Yeah, I definitely agree. There is something different happening right now. One of the, I think, clearest examples that this moment is different is that there was a recent study done by Monmouth University, and there have been frequent studies gauging race relations and kind of racial sentiment among the general population. And just in early June, I believe it was, they conducted a poll and asked people whether or not they think race is still a significant problem in this country. And it was shocking because they registered the largest swing in white responses indicating that there was a significant racial problem in this country than they've ever registered before, right? So I
Mhm.
believe one of the more recent polls was taken in about 2015. And again, even that, right, was after the Black Lives Matter movement. And at that point, the percentage of white respondents willing to acknowledge that race was still a significant problem had gone up just over 50%. Prior to that time, it had been going down. Again, this backlash against affirmative action, it had been steadily declining over the decades. But in 2015, again, after the Trayvon Martin, the Michael Brown, the Eric Garner, it had gone up. It was just over 50%. They did it in early June. Over 70% of white respondents now
Mm,
think that race discrimination is a significant problem in this country.
mm,
That's huge. That's really, really huge. And I think that it speaks to the kind of socio political moment that we're in. Now, I have to say, I am encouraged by the social activism. I am encouraged by the political activism. I am still not entirely encouraged that the Supreme Court, right, or the law is going to respond accordingly to this moment. So you mentioned
mm,
a few moments ago that there has been a statement that the way to get beyond race discrimination is to stop discriminating on the basis of race. Um, those words were actually written by Chief Justice Roberts in a
right.
case involving the use of race conscious admissions in K through 12 education. And that was just in 2007. So I think that I'm not encouraged that this court is as receptive. This is also the same man who, in the Shelby County versus, in the Holder versus Shelby County case, he said, we don't any longer need pre-clearance under the Voting Rights Act because we no longer have discrimination in voting. Right. And so in 2013, we removed, right, a critical protection against voting discrimination because Chief Justice Roberts said in our contemporary society, discrimination against racial minorities and voting is not a thing.
Mhm.
And yet here we are in 2020 where voter disenfranchisement is an everyday thing. I mean, we've seen it time and time again. And these are just the primaries. We've seen, for instance, in
Mm,
places like, I think it was Minneapolis, where they normally have, 200 and some odd polling places that only had like, five or something. I mean, it was just outrageous, the
yeah, it's
kinds of
blatant.
tactics that have been engaged in. And I think the Brennan Center has done this mapping. When you map the states that have done the most to disenfranchise voters since 2003, they're all the states that would have been subject to preclearance.
Mm. Explain for folks who are listening what does pre-clearance under what did it require under the Voting Rights Act?
Right. So under the Voting Rights Act of 1965, it wasn't enough that the legislature said you can no longer discriminate on the basis of race. There were certain known recalcitrant states, right, that had simply had a very long history of engaging in voter disenfranchisement, particularly against Black and other minority citizens. So they said those jurisdictions, based on your history, right? There was a historic record of you engaging in practices to aggressively disenfranchise minority voters. We're going to require that if you try to do anything to change the electoral process in your state, you have to get clearance from the Justice Department in order to do that. So you can't change anything about voting or the kind of electoral process, which is everything that controls where you vote, how you vote, when you register, what days you vote, how long voting is, absentee ballots, all of that stuff, right? All of that, how many polling places, none of that can be altered unless you first seek pre-clearance from the Department of Justice, who will verify that those things will not have the effect of disenfranchising minority voters. And so pre-clearance was a critical backstop, right, to preventing states who were inclined to engage in widespread voter disenfranchisement. Now, we still do, and thankfully, we have lots of civil rights organizations who are still using Voting Rights Act to actually sue these states after the fact. But that is a much less useful remedy than being able to stop them before they engage in these practices.
Right. Right. So I think one of the things that I always find really challenging, I mean, going back to what you said about Chief Justice Roberts and the claim that he made that, we don't need pre-clearance anymore because the kind of race-based voter suppression that we were concerned about when the Voting Rights Act was passed in the 60s is no longer an issue for us. And there's something about that sort of willful blindness to the world in which we live that's incredibly difficult to make sense of, right? You can see these lines in poor communities and majority minority communities where people are standing in line for 3, 4, 5 hours in order to be able to vote, where you're shutting down all sorts of polling places so that people are pushed into a very small number of places, where we still see felon disenfranchisement all over the place, right? All these sorts of things that are happening. What is it that we have to show Chief Justice Roberts and other, more conservative folks on the Supreme Court in order for them to believe the ways in which race is still deeply salient and problematic in this country? Or do we just give up on them and wait until some new justices end up on the court?
So I don't want to be too negative about the prospects for Chief Justice Roberts, although I have to say I'm not particularly encouraged because what he's engaging in, and I think it's really important what you said. it's willful blindness, right?
Mhm.
It's not what we talk about, right? So in diversity circles among diversity practitioners, and again, another term that's been highly popularized lately is implicit bias, right? So this is
Mhm.
not something that he's just unaware of what he's doing. I think this is a deliberate and willful blindness. This is just turning a blind eye. This is just being unwilling to acknowledge the facts in front of your nose because it does not serve your intended end, which is to move towards this colorblind world, right? Like the reality of the situation be damned. I'm simply going to close my eyes and say, the world that I want to live in is a colorblind world. So I'm going to force that reality on everyone, notwithstanding the world we live in. So I do think that that's what Chief Justice Roberts is engaged in. So I'm not optimistic. That being said, I mean, he did vote with the liberal justices on, for instance, a case about discrimination in jury deliberations in the criminal justice context. So I don't know. And that he thought was extraordinarily blatant. This is when I don't remember the name of the case. I wish that I could. But where, and I think it was a Hispanic defendant, and during the jury deliberations, one of the jurors said, it's a shame that, Hispanics are just more prone to crime or something like that, right? And so blatantly expresses, right, these racially discriminatory, really racist attitudes, right? And so thereby infecting the deliberative process of that particular jury and depriving this criminal defendant of his right to due process. And so, insofar as a fair and impartial jury. So Chief Justice Roberts found that that was egregious, right? And that had to be thrown out, and constitutional law would not allow that to stand. So if it's really, really egregious, although I have to say, in the Shelby County case, there was evidence in the record that was fairly egregious of legislatures in Shelby County, Alabama, talking about their desire to disenfranchise Black people. So
Mhm.
again, I think it's willful blindness. I think that there might be some occasional victories, particularly because he is sympathetic to the appearance of impartiality on the court and in his own role as Chief Justice of the court. But I don't think that that's going to get us very far with him.
Right. You spoke a little bit ago about the poll from or survey from Monmouth County and talking about this shift in how a lot of white people who were surveyed are thinking about race and racism and the continued presence. Derek Bell might say the permanence of racism in this country. So what do we do with this moment, right? Particularly if we're in a position where we think that the Supreme Court is not necessarily going to be a friend to us. What are the ways in which we can harness what's going on in the world right now so that we can become a better country and become a better society and really grapple with the deep-seated racial issues that have been a part of this country since its inception?
Yeah, I think that, as I said before, I'm encouraged by the social and political activism that's going on. And I think that we might have to realize that while the Supreme Court has been an incredible force for civil rights in the past, it is not that today. Right.
Mm.
And so we have to recognize that there are three branches of government. There are the political branches, the executive and the legislative branch, and then there's the judicial branch. And we've relied for a very long time, quite frankly, since the civil rights movement, heavily on the judicial branch to advance civil rights. I mean, I just don't think that we have a favorable judiciary right now. So we have to rely on the political branches. And that's where we're seeing a lot of energy. That's where we're seeing a lot of activism. That's where we're seeing, quite frankly, a lot of opportunity for change. And so we're seeing these, for instance, defund the police movements, right?
Mm.
That's a political thing. We don't need the court to get us to defund the police. Now, we do talk about changing the standards for immunity for police officers so that they can be held liable when they engage in these bad actions. And yes, that will require the courts to change the law. But again, that's kind of like the backstop that I talked about with the Voting Rights Act. You can sue after they've already done something bad, but the ideal thing is being able to hold them accountable on the front end so they don't do these bad things, right? Kind of like pre-clearance to the Voting Rights Act. So defunding the police and really engaging in systemic change around policing and criminal justice in this country is, I think, what we need more of. So we've seen a wave of progressive district attorneys who have been elected all across the country and who are moving us in, I think, a more progressive direction in terms of criminal justice. I know a lot of constitutional law scholars are now talking about state law and state constitutions and state courts as avenues. And again, I know that that's still the judicial branch, but I think that again, we've relied too heavily on the Supreme Court and federal law. There are lots of avenues for us to engage in activism and lots of avenues for us to seek change in our political system. And the federal courts are just one of them. And if they're not amenable, if they're not sympathetic, which I don't think that they are right now, then we'll have to find that ally elsewhere, right? The political branches in state courts under state constitutions. And that work is being done. And so I am encouraged by what's going on in the political and social arena, even if I am disheartened by what's going on at the federal judicial level.
Hmm. I want to again sort of go back a little bit because we are in this really interesting time where hopefully we can harness some of the energy that's out there right now. When you were talking about these conversations about defunding the police, there I think are more sort of mainstream conversations going on now about prison abolition and what that would look like, and just these sort of forms of criminal justice reform and policing reform that are so much more progressive than, what we had been talking about, certainly on a large scale, even I would say even six months ago. And I think that it's often hard for people to understand, what it means to say defund the police, or what it would look like to say let's abolish prisons. So let's talk about that just sort of a little bit, right? Because when people say defund the police, they're not actually saying dismantle the entirety of the police force, right? So what are they saying then?
So, what they're saying is that we use the police to address all manner of social ills that they are ill equipped and inappropriate to address, right? So, a not insignificant number of these shooting incidents, certainly not the highest profile ones like George Floyd or Eric Garner or Michael Brown, but some of the other ones have involved people who have mental health issues and who have had the police called as an intervention around a mental health crisis. And the police respond to these people clearly in a mental health crisis and shoot and kill them.
Hmm.
Police should not be responding to mental health crises. We should have mental health professionals, people who are trained to deal with these situations, responding to those kinds of things. And so I do think that part of it is that we have the police doing things that are well outside of their expertise in terms of law enforcement. And all of those jobs should be withdrawn from them. Similarly, we saw, for instance, out in LA, that we have too many police in elementary and high schools, right? We have too
Mm-hmm.
many police policing our children. In school discipline should not be a matter of law enforcement.
Sure.
Right? That should be a matter of educational policy and educational administrators. And so pulling police out of schools, pulling police out of the area of mental health management. And, one of the things that also I think we're talking about when we talk about defunding the police is demilitarizing the police. And so a
Mm-hmm.
lot of people don't know that our local law enforcement get a lot of military surplus from the federal government. And again, the vast majority of what our local law enforcement is charged to do does not require military equipment,
Mm-hmm.
right? And so there's just no reason for police to be so heavily armed and equipped to go out and to patrol our communities to make sure that they are safe. In many ways, they present the greatest threat to our communities when they are so heavily armed, and not just heavily armed, but then imbued, right, with this idea that they are a military force.
Mm-hmm.
And so, again, defunding the police is also about demilitarizing the police. And so I think that those are two really critical aspects of defunding the police, taking the police out of processes and circumstances where their presence is inappropriate, like in schools and like in dealing with mental health crises, and then really demilitarizing them.
Absolutely. So I want to ask you, actually, so one thing that I was thinking about when you were talking, and I'll say this and then I'll ask you the next question, is I was thinking about that shift that a lot of cities took at various points, which was We have people calling 911 for things that they shouldn't be calling 911 for, right? Like they're complaining about somebody, taking their parking spot or sort of ridiculous things like that. And so they created another system, 311, that you could call for these other things that are not emergencies, that are not for the police to respond to. And, that might be a way for people to start to try to understand, what does it mean to say that the police are not the folks that we should be looking to for every single thing that potentially goes wrong in one's world. So the last thing that I want to ask you as our time is winding down here, obviously you and I are both legal academics. We spend our days with law students and we are training new lawyers to go out into the world. What would you say, or what do you feel is your responsibility, our institutional responsibility as people who are churning out new attorneys every year, to ensure that those folks are going out into the world and can use their law degrees in ways that are productive and hopefully in ways that are producing justice?
Yeah, very important. Something that obviously weighs heavily on all of us as academics, but particularly in this moment. And I think that one of the things that strikes me the most about our responsibility is to really, and again, I want to go back to this point about Chief Justice Roberts and his willful ignorance. I do think that there is just a lot of ignorance, people who just don't know. And it's in many ways the fault of our larger system of education, obviously not just higher education and certainly not law school. But I think that it is incumbent upon all of us who are in any way involved in the educational arena to make sure that we are equipping the people who are in our charge with the knowledge, right, to go out into the world and to do good and to be useful. And for me, because I am a race law scholar and I do diversity work, I teach classes like diversity in the law, which really goes through a range of not just marginalized groups, but kind of historic accounts of not just Native Americans and not just Blacks in terms of slavery, but also Japanese internment and even people that have sovereignty issues like Puerto Ricans and even Hawaii before they became a state, dealing with all of this historic knowledge that so often is siloed in the academy and among those people whose job it is to be well informed. But I think we also have to understand that it is our job to make sure that everyone else is well informed as well. So not just to our students, but it's also part of the reason why I try to have my scholarship be publicly engaged, because I want my impact to be broader than the classroom. I want everyone to be able to have access to this information about the ugly history of America, a history that we have not yet escaped. And quite frankly, many people think we will not escape until we first confront, right? And so Chief Justice Roberts' approach of willful ignorance keeps us trapped in a position where we cannot make meaningful progress because it requires that we first confront, right? It requires that we first acknowledge. It requires that we first inform ourselves about how we got here and why we are still mired in these difficult, knotty racial and other social justice issues before we can even hope to move forward.
Absolutely. Well, that's a perfect place to end. So I want to thank you so much for this conversation. I really appreciate your time, and I certainly appreciate your words and your thoughtfulness and the work that you do both in the law school and outside of the law school. So I'm lucky to have you as a colleague. So thank you so much for your time, and I will look forward to when we can actually be in the same space again. Won't that be nice?
Absolutely. It's been a pleasure. Thank you for having me.
Of course. Take care.
Bye-bye.
The Power of Attorney is produced by Rutgers Law School. With 2 locations, minutes from Philadelphia and New York City, Rutgers Law offers the prestige and reputation of a large, nationally known university with a personal, small campus experience. Learn more by visiting law.rutgers.edu.